why don't we go ahead and start with some brief introductions and some guidelines. So very pleased that everyone can join us today. This is part 3 of the seminar series put on by Sahouri Insurance and General Counsel PC attorneys at law. Parts 1 and 2 are available, I know, on the General Counsel website. I imagine they're available on the Sahouri website also, but contact any of the presenters today if you have questions or want links to parts 1 and 2. If you have any questions as we go through today, please use the chat function within the webinar. So at the bottom of your screen, there should be a chat functionality. It has a little circle with 3 dots in it. Use that to submit any questions you have, and I will be sure to answer those as they come up if possible, or at the end. So thank you for that. And with that, let me go ahead and start some introductions, and then we'll go from there. So my name is Merrick Green. I'm going to moderate the discussion today. As the slide says, I'm the founder and managing partner of General Counsel PC. I also manage our employment law practice. Started General Counsel PC in 2004. So for the past 16 years, we've served as an outside general counsel to businesses, nonprofits, and executives throughout the DC metropolitan area. We're located in McLean, Virginia, and we have 5 primary practice areas. So we do full corporate business M&A practice. As Rhodes will discuss, we have a full GovCon bid protest practice. We have employment law practice where we're representing employers and then executives, often with severance agreements or non-compete issues. We have a state federal court litigation practice, both in Virginia, Maryland, and DC, state federal courts. And this year we also added a family law practice. So if we can help you in any way on any of those issues, please let us know. And with that, Louis, do you want to give a little of your background and your information?
Sure. As Merritt said, I'm here at General Counsel. I run our government contracts practice group, and we're kind of holistic with our abilities here in the GovCon group. We handle all matters of government contracting issues, bid protest and claims, your GovCon litigation, as well as corporate issues, teaming agreements. Actually, I think I've got 3 teaming agreements open on my desktop now. So we do the corporate side as well as the general commercial corporate employment law. We work with all the practice groups here. I've spent about 7 years as an in-house counsel, mostly in government contractors and mostly in smaller businesses. So I got to do a little bit of soup to nuts when I was there, kind of doing the like most small businesses, your executives do a little bit of everything. Relevant to this discussion is, in some of those jobs, I also held the Chief Compliance Officer title, where I was in charge of doing all the internal investigations relating to, related to any internal matters, be it government contracts, ethics, compliance, or employment issues.
Great. And Alan, it's good to see you. Why don't you go ahead and just give a quick introduction of Sahouri and the scope of services you all provide and your role within Sahouri.
Sure. Yeah, thanks. And I wasn't late, but coming from my office to my house, my computer reconfigured everything. So, my split screen had to fix, my Ring Central had to re-download. It's crazy, but yeah, better late than never.
Your timing was perfect.
It was good. All right. Wonderful. Well, yeah, so Sahouri Insurance, been in the business for about 50 years now, having our 50th anniversary, and always been in DC serving the federal government and the government contracting community. We've last, I'd say, decade started focusing on a lot of foreign operations in the U.S. And now also sort of domestic operations operating overseas. I am the sort of the practice leader, not the practice leader, the director of the property and casualty department over here. And I teach insurance to insurance professionals, certified insurance counselor designations. So
great.
Yeah.
Well, thank you for that. And General Counsel's worked with Sahouri over the last few years. So I can say that they provide wonderful services, and pleased that we've been able to do this webinar series with you all. We're going to try to keep this relatively informal. We do have a PowerPoint with general information, but we'll keep it conversational. We're trying to limit Lewis a little bit on the stories he can tell. So, you know, we'll see how that goes and whether we'll be successful or not. But as I mentioned, for folks that have just signed in, please use the chat function at the bottom of your screen for any questions that we go along. So, as we said, today what we're talking about is claims, complaints, and investigations, you know, issues impacting EPL and other insurance coverage. So, and for many businesses, this is maybe not something that you're thinking about all the time, but it is vitally important. So why don't we start with Alan giving a little bit of an overview of insurance coverage and things that, you know, businesses should have in place and some of the primary issues that come up in such policies.
Right. Thank you, Merritt. Yeah, and I think the reason why we wanted to touch on this first and foremost is because when Lewis goes through the actual process of investigation of claims or allegations, you know, there are things that you want in place. Just have it ready, have it structured this way to really allow for a smooth claims process, you know, a claims and investigation process that won't be hindered or in any way, shape, or form affected by the insurance coverage you have. And it doesn't take a lot of time to cover this. You want to make sure that your D&O, EPL, and crime policies, which are the three policies that are going to be triggered in the event of a claim, whether it's discrimination or employment related, or whether it's criminal or fiduciary in nature. So duty to defend versus reimbursement, real quick, what is that? A duty to defend policy means that the carrier elects the counsel, and they have each carrier probably has one or two national contracts with a law firm that probably does specialize in, let's say, either discrimination or crime, but it's pre-negotiated rates, and they're working on thousands, if not tens of thousands of claims potentially all over the country. So you're not going to get that personal service you deserve. You need to get reimbursement, right? What that means isn't that you pay out of pocket until the claim is settled, right? It means as you incur those costs, you can send the invoice and be reimbursed immediately. So it's not like, oh, you got to wait forever. But the key is, the big difference is you choose the counsel, right? Not the carrier. So you don't have and that's going to be very pertinent when we talk about what the hammer clause is real quick. So really make sure you have reimbursement. The cost is nil. It literally costs you nothing. It is your right to choose. But
now, Alan, let me ask you just a quick question, if you don't mind.
Yeah.
Is oftentimes when I'll see employers with a EPL policy, employment practices liability, it's often EPLI. They're 9 out of 10 times it's a duty to defend instead of reimbursement. Yeah. They don't have the right to choose legal counsel, and oftentimes they'll get very annoyed. In fact, we were dealing with this with a recent client who had a wage and hour lawsuit filed against them, because his concern was the insurance company is going to try to settle a matter as quickly as possible, and he didn't necessarily want that to happen because he didn't feel as though they did anything wrong whatsoever, and they didn't want to set a bad precedent for other employees. Yep. So how hard is it for that employer to go in and make those changes to the policy so they have reimbursement?
It isn't. In fact, Merritt, that's a great question, because like I'm halfway through writing this sort of short story about, or short narrative, 101 coverages. There's over 101 things that if you ask the carrier to provide you, they'll provide it for you free of charge. They're not even charging for it. And what does that say, really? That speaks volumes, because it's like, almost like, oh, we're busted. Yeah. Oh, you knew about the hammer clause. Oh, you knew about the reimbursement. Yeah, sorry, here, you can have it. So yes, it's a great question. And the reason why 9 out of 10 policies don't have reimbursement or don't have a favorable hammer clause, which is what you were alluding to as far as settlement, is because it wasn't asked for, right? Unfortunately, the barrier to entry to become an insurance agent is a little different than becoming an attorney. Okay, getting your bar, sitting on the bar. There are some elements to upper echelon learning, but really the average agent is not going to know about most of these things.
And just quickly, there's no additional cost to the employer or the company. So duty to defend might be all the way up to, $300,000, reimbursements only to $100,000, or is it really apples to apples? Just
no, it's really just the language of the contract. It doesn't speak to limits at all. It speaks to, we will provide you with defense, or you will provide defense, and you provide them essentially with who your named legal counsel is before a claim even occurs.
That's great.
Yeah.
Excellent. All right. Well, let's keep going. I'm committed to have us done by noon. So I think we need to finish up that prior slide, Sydney. I think there are 2 more points to talk about.
Yeah, real quick.
I'll stop asking questions.
That's great. And so another thing that if anything was going to cost money, it might be having the defense cost be inside of the limits or outside of the limits. And when I talk about differences in premium, I'm talking about less than maybe 2 or 3 points, right? So if you're paying $1,000 for $1,030, you can have a separate limit for your defense costs, for your legal fees. So that would not erode the actual, if any, settlement, judgment, or award that your $1 million limit provides. So you absolutely want to set that aside, right? And then last but not least, the hammer clause. And that is simply saying, like you mentioned before, without telling the carrier that you want better terms, the carrier, if they're able to negotiate a settled amount with the plaintiff or the claimant, if they're able to reach that agreement, let's say it's $20,000 to, sweep a sexual harassment claim under, not sweep it away, but, settle it. Well, like you said, what does settlement amount to in public or to your other employees? So whatever it amounts to, it's not as good as being able to kind of continue to prove your innocence. And if they're able to settle for that agreed amount, the carrier on unendorsed policy is literally allowed to say, all right, here's your check, Lewis, here's your check, Merritt. Good luck. You're on your own. We could have settled it. You said no. So we are off the hook for what we could have settled it for. Well, that's not fair, right? And so what is a better, hammer clause is, no, you are 100% with us until we mutually agree to either settle or defend this, all the way through. Now, that language we'll have to get to later, but what we'll typically find is, without question, they will accept sort of a 70-30 or an 80-20 agreement, which means if after a settlement you don't want to settle, we're only on the hook for 70% of defense costs moving forward, right? Mm-hmm. But we're not paying for anything beyond that number. So that's important, and that's about as best as I can describe these 3 things. You want to focus on, you want to have reimbursement coverage, you want to have defense outside the limits ideally, and you want them to, quote unquote, waive the hammer clause. They may come back and say, well, we won't waive it, but we'll do 70-30. And that's agreeable, I guess. But that's off the shelf. You're getting duty to defend, defense is inside the limits, and they are off the hook 100% if they're able to reach a settlement.
So everyone listening here today should, go back, look at their premiums, have you look at their policies if they're not already with Sahouri, and determine whether they have the right policies in place. What about
there's no sales job there either. You can literally see it. You either have it or you don't.
What about different types of businesses? So, you have a technology company that just does commercial work, is not in government contracts, to, someone who's a government contractor. Are there different types of coverage and policies that they need?
Well, so no, really there aren't. I mean, in terms of D&O, EPLI, now professional liability is going to be dependent on the services they're providing. Crime, there might be some bonding issues, but as far as when it comes to claims and reporting, and as Lewis will go into, the investigation, the carriers there aren't material differences in the way the carriers provide the coverage.
Great. Excellent. All right, well, let's go ahead and Lewis has been very patient so far. You know, he's like a racehorse ready to go. So and one of the things that, you know, one, it might be the former Boy Scout in me, but, you know, our best clients are always the clients that proactively are prepared. They have the policies and procedures in place. So Lewis, you know, why don't you talk about a little bit about what, you know, you did in-house, what we do for our clients now, you know, sort of the best offense oftentimes is a great defense. So how do we get prepared?
Yeah, no, absolutely. And, you know, whenever anything happens in a company, you're going to look to see what your policy says to do it, whether it's putting together a proposal, how do you get approvals to spend B&P dollars, et cetera? How do you get reimbursements, right? You have policies for all that. You need one that addresses these types of issues before you need them. You don't want to start making up how you're going to conduct an investigation on the fly after you get a complaint. You should have an investigation policy that says, here's who gets notified. And, you know, if those people, what if, you know, the person who's your normal investigating officer is the one that complains about, right? You have to have a policy that addresses those types of issues. You know, ethics and compliance policy, you know, those are titled. They're titled because if you're a government contractor, there's an actual FAR requirements about things you need to have as your ethics policy. If you're a tiny little micro business, you don't have to have a full policy yet. But once you hit a certain employee size, you need to have a hotline, you need to have a policy, you need to provide training annually. You need all those things before the hotline phone rings or someone sends an email complaining of a fraud, waste, and abuse or an ethics violation. You know, and I will tell you, I've found this out the hard way a few times. You know, at the end of an investigation or at the end of a complaint, whether it be an employment issue or an ethics compliance issue, the government's going to ask to see your policy and how you followed it. This comes through a lot in the employment context, as I'm sure Mary can chime in on too. You know, when you go through a policy, if you've got an EEO violation complaint, the government's going to want to see what your policy is and then how you followed your policy for handling any kind of complaint. So you need those, and they need to be thought out because you want to make sure that you're covering all the different angles and contingencies. It makes the investigation process a lot easier.
You know, and in that regard, you know, especially in the employment context, it is essential that you have these policies and procedures in place. Not only because it can be required by law, you know, under some of the employment laws and OSHA, you know, an employer is required to investigate after some complaints. But pursuant to U.S. Supreme Court precedent, an employer has an affirmative defense to certain employee complaints and from liability if the employer has policies in place to handle harassment complaints and the employee does not follow those procedures. So, you know, imagine that, you know, you don't have those policies and procedures in place. You can open yourself up to a lawsuit that otherwise can be avoided. So it is absolutely essential within an employee handbook and other documentation that you have policies and procedures in place for some employee feels that they're being harassed or otherwise. So that is absolutely vital in that regard.
But then on the ethics and compliance piece, it gets even scarier because you're talking about if you do something wrong there, you're putting on an orange jumpsuit. This is criminal. And I've seen people go to prison over violating, you know, ethics and fraud on the government. And, you know, one of the things that, and companies get fined a lot of money. And one of the things the government's going to look at is your policy and whether you followed your policy when you got a complaint. If some executive gets a complaint and tries to sweep it under the rug, that company is going to get hammered. So, you know, these policies are some of the most vital ones. You know, they're the ones, they're like your fire extinguisher, really. They're the ones you hope you never want to need, but when you need them, you really, really hope you have them. Because the cost of not having them is enormous.
You know, and I don't want anyone to sign off the webinar right now, but I'd almost say the two things that we've talked about thus far are probably two of the most important things that, you know, if you remember something from today, it's number one, make sure you have good policies in place that have some of the provisions that Alan was talking about. And number two, make sure you're prepared. Have the policies and procedures in place. And as part of that, make sure you've done training as it relates to them. As part of the affirmative defense for employment law matters, you need to do harassment, anti-discrimination training for your employees, for the supervisors. So really, be prepared. And if you're prepared, it makes a lot of the other investigation, other issues a little bit easier because you've thought it through and done the legwork. So why don't we go on to the next slide, which is triggers for investigations. And Lewis, why don't you go ahead and take some of the lead here again?
Yeah, so here there's lots of ways information can come in, and frankly, I've received complaints and done investigations under each one of these. Obviously, you have your hotline. If you're a government contractor, you're required to have a hotline once you hit a certain size standard. All right, I've had offices where the phone sat on a desk in my office, and it was literally the bat phone, and I think I jumped out of my chair like in fright the first time it rang. But those are standard. The bigger companies will actually completely outsource. I worked for one company. We had employees all over the world. We had a third party that handled our hotlines. And that, if you're big enough that you can afford that, that's worthwhile because they would triage it themselves, and they knew who to send the report to based on who the complainant was. Right, I received most of the complaints, but if I was the bad boy and they were reporting on me, the company knew not to email me the report, even though I was the chief compliance officer. Thankfully, I was never personally investigated. HR complaints, we all know how that works. Emails. One time I got an email from a anonymous@gmail.com. Guy set up an email just to email me a question about saying that he thought we were violating the ethics by inviting a contracting officer to lunch, which, believe it or not, if you pay more than $25 for that lunch, is a ethical violation. But it came to me via email, and it came to me directly because I got around and I did the training and I talked to the employees. Companies and executives that you have these policies. There's this mentality that, hey, I don't want to encourage people to report, which I think is absolutely wrong. You want to encourage people to report because they're more likely to ask questions. And, when I was an in-house guy and I did this training, I told people I'd rather field 99 innocent questions that amounted to no violations than deal with one actual violation. And when you set a corporate culture where people are willing and encouraged to report things, people are going to be careful before they try to cheat and violate the law and do anything unethical because they're going to feel like, their colleagues are going to be more than willing to report them based on the tone of the company.
Well, and Lewis, I imagine that you would always rather hear about something the company is doing wrong and be able to proactively address it and notify the government as need be, then have the government contracting officer or someone else send you call you or send a letter saying we've been notified by XYZ that your company is doing ABC, please advise your status on this $1 billion contract is now in jeopardy.
No, absolutely. The last thing you want to do is hear from the government. You want to control what goes to the government. We'll talk later about what you have to report and how you have to report it. But the further upstream you are on a problem, the better off it is. And this gets to your whole corporate culture. You want to have a company where people are encouraged to report. And that's where I talk about the office interactions. A lot of times people think, oh, I'm only responsible for doing an investigation or reporting if somebody makes a formal complaint. If I'm in the lunchroom and there's a couple female employees in that lunchroom, and one of the two of them starts talking about how one of the executives of the company, backed her into a corner and was very inappropriate, that needs to be addressed. If you're an executive of a company and you hear that kind of stuff while you're walking around in your company, guess what, company? You now have actual knowledge of this issue, whether it's formally reported or not. And I think Alan will talk about in a second, like when does that knowledge cover reporting to the insurance company, because insurance companies love to deny coverage when they can. So if you hear stuff and it's not reported, and it comes up 3 weeks later, that time you heard it is when you should have taken action. So don't sit back and say, I need a formal report before I need to do something. If you're out moving around, interacting with people in the company and you hear stuff, and I'm not talking just me as the general counsel compliance officer, if you're an executive or an officer of the company the company knows what you know. And if you know something and you don't follow up on it, that's a bad day for the company.
I was going to say on the flip side, it's funny. It's so many of the words we use are interchangeable between legal and in the insurance world, whether it's policy, triggers, notices. There's a whole infrastructure in the contract as to what is noticeable. Like, in other words, what would be considered something that is relevant, and then also who isn't insured as far as when you are obliged to notify the carrier, right? So there is an entire paragraph that defines what knowledge of occurrence means, right? And who needs to be knowledgeable, who needs to be aware of it for it to have been known. And you is not just the owner, the principal, the CEO. You is, in some policies, it's as limited as the CEO, COO, Chief Compliance Officer, if applicable, and the Human Resources Manager. The people that, at best, in worst case, you would assume know better, right? But then there are broader policies, like on the E&S market, or, if you've had a claim before, where all of a sudden that definition gets real broad. And anyone that is of a supervisor capacity is a you, and there is an insured, and is therefore obligated to notify the carrier. Ultimately, they're obligated to notify their principal or their supervisor, their higher up. But if that is the definition of knowledge of occurrence, then you as the owner or the principal or the executive have to recognize that all of those people that you're putting in that position are you as far as the carrier is concerned. And if they're aware of something and they're not sure about when to report it or how to report it, you can have your coverage denied as if you yourself did not appropriately notify the carrier in a timely manner.
Well, and what's amazing is I imagine that, 80%, of everyone participating and listening to the seminar today, unless they're Sahouri or hopefully general counsel clients, aren't aware of that requirement and don't know whether or not that's in their policy. But we're jumping ahead a little bit. So why don't we get to the next slide? And I know Alan will go back to insurance reporting in the slide after this one. Oh. But Lewis, talk a little bit about some of these investigation preliminary issues. Yeah,
so when you get a complaint, the first thing you don't, like anything else, you don't want to just run off and start to the races. You want to sit down for a second and plan and scope it. All right, there's complaints, and when you've been doing this for a while, you can get a pretty good flavor for whether the severity of the issue in the complaint. When I got an email saying, hey, we invited a contracting officer to lunch and it was a violation, I just merely needed to get the price of the pizza that we ordered and divide it by the number of people and figure out the cost per head, right? That was very simple. That was an easy one. These can get fairly complex. Now, the one most important thing in here is right up front, who's going to do the investigation? There's a lot of instances where big companies have audit departments, or it's an employee complaint and they figure, hey, we're going to have HR handle it. Well, there's this thing called attorney work product privilege, and an investigation handled by an attorney is subject to that privilege and does not get disclosed to an opposing plaintiff or to the government. There was a really, really ugly case decided about 7 or 8 years ago involving KBR, where KBR was using its auditors to do some investigations. And the court held that, well, because attorneys weren't doing it directly, then they weren't subject to the work product protections and they had to be disclosed to the Department of Justice. That case was one of the most scary cases that have hit the GovCon arena in a long time. Now, that case was thankfully narrowed and overturned on some of those grounds, but it is an issue that you need to think about when you start to do an investigation.
Just quickly, what oftentimes, just quickly, what we'll oftentimes say to one of our clients, and I'm sure Alan would advise this to everyone that has policies with them, is you get that complaint. The first step is, hopefully, you have policies and procedures in place, call legal counsel that you're working with. Say that we just got this complaint, come up with that strategy and how you're going to deal with it and how best to do that investigation. Oftentimes what we'll do is, if it's an employment-related complaint, the investigation could be done by that in-house, HR staff, because lots of times perhaps bringing in legal counsel on a sexual harassment or other discrimination complaint, it might be an escalation beyond what you need, but it has to be done under the supervision of legal counsel, and you can still then have that work product. So, just quickly, and sometimes it's good to sort of define the rules. So to have the protection, and a lot of what you want to do is here, if you're doing an in-house investigation, you don't want all those documents just to be turned over to plaintiff's counsel if a lawsuit ever ensues. So it's, you have three sort of requirements to have this work product privilege. Information must be otherwise discoverable. So let's say internal interview notes, and internal communications, things along those lines, must be prepared in anticipation of litigation. So if there is an internal complaint of some sort, you have to assume that there's the possibility that that could turn into litigation. So that's part two, anticipation of litigation. And three, the material must have been prepared by or for a party to the lawsuit or by the party's representative. So that's, again, why we will say, if you're going to do this investigation, great, but it's an anticipation of litigation. Everything on it, you should try to use attorney work product and confidential within those communications, and you want to sort of narrowly define who has access to that. If you start sending things to your CPA, you're going to lose that protection. So very important at the beginning to talk to legal counsel about those issues. Back to you, Liz.
Well, even farther than that, Merritt, when I was an in-house counsel, I would often write a letter to the HR director instructing them to do the investigation, identifying the scope of the investigation, and laying out the ground rules, which therefore kind of cloaked it as they were working for me as my agent, as the attorney, which carried them under the attorney work product protections. And we can do the same kind of thing as an outside counsel if we're basically designing the game plan, and it's like we're the head coach on the football team coming up with the game plan. You want to identify the scope. Although I at the risk of telling stories, but this is a very telling one, and one worth I like to get out there. You got to be careful in boxing in an investigation. I worked for a company that provided services in Iraq, and we received a complaint of sexual harassment discrimination against one of the site leads over there. And luckily, the investigation landed in my lap. And as I was doing the investigation, it turned out that the individual was submitting false timesheets to the company, which now raised a false claim issue for the government. So even though this started as a harassment investigation, it very quickly, blossomed into something that could have been absolutely catastrophic for the company. So don't necessarily think when you start digging that you're not going to find something else. My experience has been, if people are bad in one area and they're going to break the rules in how they treat their employees, they're probably unethical across the board. So you really want to make sure that you keep your aperture open so you can see the whole picture and don't narrow the scope too much. And the last thing, and oh my God, it's 2021, and you would think we know better. you know, you can't turn around and go after a complainant, even if you think the complainant is totally out of line. Like, you can't retaliate. If a complaint is filed in good faith as a ethics complaint or an employment complaint, that complaint is now protected by federal law and state law, whether you're a government contractor or not, right? You can't fire someone for complaining that they're being harassed or saying, hey, we don't think you're complying with your contract requirements, right? I can't tell you the number of times people are like, I want to do this to this person. They're full of crap, and this is not. If it's a good faith report, you need to make sure that that person is not retaliated against. On the flip side, that doesn't mean that employee can now just start coming into work at 10 o'clock in the morning looking like they slept in their clothes, right? They still have, you're not bulletproof if you complain about something. But again, if you have an employee who's a bit of an issue who makes a complaint and this can very quickly get ugly. Merritt, I'm sure you've had more than enough litigation on both sides on this issue. You can fire people even after they make a complaint as long as it's unrelated to the complaint. But you definitely need to call a lawyer before you do something like that.
Yeah, and just to quickly reiterate on that, especially in the employment context, someone makes a harassment lawsuit, an allegation of some sort. Lots of times some of those complaints might happen, shortly before or after someone gets on a PIP or otherwise isn't performing well. They feel that their supervisor's being unnecessarily tough on them. And let's say that harassment claim has absolutely no merit whatsoever. And you determine that after investigation. What happens sometimes is that supervisor or the company gets annoyed and they fire the person. You have more legitimate retaliation lawsuits than oftentimes you have the underlying harassment lawsuit or claims. So you just need to be outrageously careful. I think there are more retaliation claims filed at the EEOC than any other type of claim. So just be very careful. Know you're not bulletproof, but once you file that claim, you do have a bit of protection. And as a company, you would have to be very careful with documentation, creating a paper trail before you let anyone go in that regard. So just always be very careful. Then move on to insurance reporting. And, Alan, why don't you take the lead here? And, Lewis, maybe you can chime in and from your in-house experience when it's good to advise a client to report. But Alan, to you.
Yeah, so you cover on a couple of good points, and that is, we talked about knowledge of occurrence, right? Who is responsible? Like who needs to be aware of it for it to actually start the clock in terms of whether or not it needs to be reported. What you talked about a moment ago has to do with, what level, right? Does it really necessitate reporting? I would definitely encourage any sexual harassment related claims, especially if it's more than just like a first sort of instance where there was no sort of physical contact, but it just made someone feel uncomfortable. I don't want to get into too much detail about that, but between speaking to counsel and notifying your agent, see, a lot of people don't realize that the agent is actually a representative of the carrier. And some agents make it a business to report any notices that you send to them to the carrier. Why? Because that ends up on your loss runs. I've seen a lot of loss runs where you've got 10 claims and they've all been, there's $0 costs. But as far as their marketability to other carriers, when the loss runs are requested and they see all of these notices, John Smith complained that he was wrongfully terminated. Jane Doe complained that John Smith made her feel uncomfortable, right? I mean, that makes it impossible to find reasonable insurance coverage, right? So on one side, we're not suggesting you keep it from us, keep it from the insurance the carrier. But on the flip side, if you were to report every HR instance where someone complained about someone else, and be pre-investigation notified the carrier, most agents, when you notify them of that, they'll immediately submit it to the carrier. It'll immediately become a claim that's going to be on your permanent record for 5 years. So
that's interesting because, perhaps it's I'd often thought that, your broker's there, working for you, and I've even personally, gone to a broker once or twice and said, hey, we have this issue going on. Is it something we should report to the insurance carrier? And we talk through it. So what you're saying,
that's the way to do it.
If you talk to your broker, and even if you have that discussion, they'll turn around and automatically report, either with or without your knowledge?
Correct. Yes. So the agent, being a representative officially of the carrier whose policy they have issued or they have administered, will argue that their obligation is to the carrier first.
And that's to independent agents also.
That's independent agents as well. Yes.
So what do you do in that circumstance? Obviously, you can talk to legal counsel.
Absolutely.
When do you know, and how does that business owner get advice on when to report? When is that trigger?
Well, so officially that is written in the contract, in the policy, and that would be the moment that you are aware of any claims, suits, or allegations that may give rise to a claim or a suit, and you being those certain people. Now, but again, there's a lot of ambiguity when it comes to like reasonable belief that it could give rise to. And that's why the agent, if you have the conversation in advance, and if the agent is really doing in the best interest of the client, we have a lot of work. We have the best way to move, the best way to operate is with someone like you or Lewis and an agent that in advance says, look, we're not in the business of filing claims unnecessarily, right? But you can you can remove a significant burden, a reporting burden, by notifying us, by involving us, right? Because the nice thing about us being representatives of the carrier is we're assuming some of that worst case exposure. We're sort of representing the carrier. By notifying us, you're letting us know without filing a claim. And if the carrier tries and say, oh, well, no, you didn't notify us. It's like, yes, I did. Yeah, they notified me, Alan, your agent, who I am a representative of that carrier. So ipso facto, like we're removing that ambiguity about whether or not we notified us or them by notifying.
That shouldn't just be a phone call. That should probably be in writing. So it also seems that everyone participating today has a certain amount of homework. Go back and look at their policies, check to see whether it's what type of policy it is, whether it's a duty to defend or reimbursement, but then also strictly define and look at their policy. When is that duty to notify triggered? And I think almost have that within part of the internal written policies of the company.
Yeah, there's a knowledge of occurrence provision that we mentioned, which who isn't insured or who needs to be notified. And then there's a section of like your responsibilities. So there's our responsibilities to you and your responsibilities to us. And in your responsibilities to us section, it will clearly define what is required to be notified. But again, that ambiguity of reasonable belief that this could give rise to a suit. That's where a good agent steps in, and you email us or you call us and we say, thank you for notifying us. And we'll even put that in writing most times, right? And we'll advise, if we believe it does warrant an official notice and a claim, we'll put that in writing. But otherwise, we'll say, I received that information. Please notify me if there's been any material changes to the investigation.
One sort of quick hypothetical. So let's say we have a situation where someone makes a harassment complaint of some sort. Company goes in, interviews the person who made the complaint, interviews the harasser, perhaps interviews one or two other folks, doing everything right. They come up with a resolution, it was a misunderstanding of sort, and everyone seems happy and the issue's resolved. At that point, no reporting obligation.
Nope.
Okay, but if after the investigation, the person who made the complaint is unhappy still, and you find that perhaps there was some merit to the complaint, you make the determination at that point.
Right, and at the second, it's like we either discover there's merit or they request some sort of injunction or financial.
Absolutely. All right, well, let's keep moving. I know we have another 15 minutes, so let's go to the next slide.
I know, but before we get off this point, I want to harken back to our policy when we talked about the investigation policies and having a handbook. You don't need to report to your insurance company within 24 hours. You generally have a week, 10 days, somewhere in that time period. So if you have a good policy on how to handle an investigation, you can do some of the fact finding well within the time of when your reporting obligation runs out. You have a window. So you want to be prepared quickly to be able to dive into this, do a little bit of factual determination before you have to make your decision. It's not like you have, a day to call your insurance company. You have a little bit of time. But again, this goes back to if your policies are not proper and you don't have a good handbook and a good investigations policy, and you flounder for 3 days trying to figure out what you're going to do, you're going to waste your time before you're going to waste that window. So this is going back to why we need to have good policies in place ahead of time.
Great. All right, Sydney, let's go ahead on to the next slide. And Lewis, why don't you take us through a little bit here? But although one thing I will say is, during these processes, make sure you're really protecting the confidentiality and being sensitive to the parties. Oftentimes you will see companies make mistakes and there are privacy issues. And then also you have to be careful of the person that's being accused. I've seen defamation lawsuits stem out of this. So again, you just have to be very careful throughout the process. But with that, Lewis, why don't you go ahead, and I guess we have about 15 more minutes.
All right. I can do this in about 5. What I will say, an investigation process is more of an art than a science. And it really is going to depend on what's being accused and who's involved. I worked at a company that did facilities maintenance, and we had a lot of wrench turner, blue collar guys. I'm not, if I need them to talk to me, I'm not showing up in a suit and tie and scaring the hell out of somebody who's going to say, oh my God, I'm not talking to this guy. I'm going to dress more like this, or maybe in a company polo shirt, make sure they know who I am, but there's a flavor to what you want to do. If I want to scare the hell out of somebody, I'm showing up in a suit and tie, and the first thing I'm doing is putting my card down that says I'm an attorney, and I'm going to then give them their I don't represent you, I represent the company speech, their upjohn warning. But the process, you really need to have someone who knows how to handle these, because these can be very nuanced, and Merritt hit it on the head, right? You don't know. A lot of people think they know. They get a complaint, like, oh, this is bull crap. John's a good guy. This would have never happened. And then it turns out John's really kind of a sleazeball. All right. So you've really got to treat every investigation seriously. You got to really digest it. You got to prepare. When you sit down and do interviews, never interview with one person. You always need 2. Even if it's just somebody sitting on the side taking notes. I want somebody else who's going to, when I say someone told me X, I need someone backing me up in the process, right? Never do a one-on-one interview, regardless of who you are, regardless of what the complaint is. I mentioned upjohn. That's a big legal thing. If you're a lawyer doing an investigation for a company, you need to make sure the employee knows that you don't represent that employee, you represent the company. A lot of times people sit down, I work for company X, oh, that's company X's attorney, so I can tell him everything. It's attorney-client privilege. No, you got to make sure you let them know, hey, listen, if you tell me something that you did wrong, there's no privilege here. I represent the company. That's another issue where things can go south in a hurry. But like I said, the biggest thing with interviews is, don't just jump in, have a plan. Like I said, I will have it nuanced in, I'll wear clothes depending on who I'm interviewing. I'll dress a certain way based on the type of the complaint and the type of the issue. Like I said, when I wanted to scare someone, I showed up in a suit and tie. If I wanted to get information and make the person, if you're more of a witness than a target, I'm going to come in a lot more casual, and I'm going to make sure you're comfortable talking to me. So there's a lot of issues in this process. You want to make sure you're thinking it through, and you're not just kind of running headlong like a bull in a china shop. I need to go get all this information and bring it all in, and I have 48 hours to decide before I call my insurance company. You want to take a breath. You want to have a plan. Talk to someone who's done these before, and then move forth smartly.
What about the difference between an ethics and an employment complaint? Or potential something related to a government contract?
Yeah, if it's an ethics type complaint or a fraud, waste, and abuse type complaint, I'm going to tell you, you really need to get the lawyers involved, and you need to have multiple lawyers doing the interviews. If it's and I don't want to say run of the mill, but if it's a standard HR complaint that, you've seen a lot, you can have HR handle the interviews. And frankly, you've got to think about whether it's you got to think about the dynamics. If you've got a woman who's complaining that she's being harassed, you don't necessarily want me coming in to be the one who's interviewing her. I'm big and I'm loud. You want somebody who can be, you want somebody who can make her feel comfortable that they can talk to. So again, the ethics complaint and the ethics issues, because of the potential damage to a company if those things are handled improperly or not done thoroughly, and it turns out that there's merit to the complaint and you don't think so. Again, people go to prison and companies go bankrupt for those issues.
Alan, quick question for you. Within the insurance policies that you have, do you ever see the panel counsel or the insurance company and their representatives get involved in the investigation process?
If the claims typically, so they have special investigation units, which are like a senior or another level of adjusters. And that they will typically get involved in liability claims, which would include any discrimination, third party, discrimination, or second party, any liability claims that exceed over, I think the threshold is usually $100,000. The carrier's adjusters, whether the insured has their own counsel or not, when within their right, will have special investigators review the details of the claim and want to get information from counsel on a regular basis.
I guess it depends on the circumstances. If it's a internal, HR complaint, everyone's still there and there hasn't been threat of a lawsuit, then it can probably be handled internally. It's probably not raised to the point where you're notifying insurance. But if it's someone who, has fired and threatened a lawsuit, or, has, resigned or otherwise said, hey, this happened, and, once the notice has been done, perhaps the insurance company gets more involved at that point, even if it's an investigation.
Yeah, so a typical investigation where it's, they won't get involved unless, as long as there's a reimbursement policy versus duty to defend. If it's duty to defend, they'll have to get involved immediately because they're going to be the ones providing, counsel.
Right.
But no, and then the criminal side, or not the criminal side, but any sort of fidelity or ethical issues, that runs into a different side of investigation, right? There's obligations on the employer's part when it comes to, for example, employee theft or employee dishonesty that require us to file police reports, actually get law enforcement involved in certain circumstances. But for the most part, no. I mean, most of these claims on unemployment are pretty laissez-faire unless they become six-figure or class action in nature.
Great. Well, Cindy, why don't we go ahead to the last slide, And before I turn it over to Lewis and Alan, just for sort of final thoughts here, one thing I want to make sure that everyone keeps in mind is during the investigation, you still have if in an employment situation, the employee who made the complaint and the harasser, and you need to be sensitive to those issues, and you might want to ask the harasser if they're still comfortable, working in the same, office environment with that person. You might not want to have the harasser, continue as the supervisor. You need to sort of, during the time of the investigation, perhaps adjust the working relationship, and talk to the person who made the complaint and be sensitive to what's going on. But you also have to do it in a manner where there's no retaliation towards the harasser, the person who made the complaint, and no potential defamation or other actions by the person who is the accused harasser. So you need to be very sensitive, but it is something that has to be considered during the investigation. You may not just be able to allow the status quo continue. So I know that following an investigation is always best practice to have a final report taken care of, and printed. Lewis, sort of any other considerations from a legal perspective?
Well, absolutely you need that report, because especially if you deem that it's not an issue and you've investigated it and you don't think there's an actual violation, you need something to go back on in case the government hears about this down the road and has a different conclusion. You want to be able to go to the government and say, hey, here's how I looked at this. Here's my report. Here's why I didn't think I needed to report it to you. You need to have that in writing. And this can come up 2 years later, right? So you definitely need to have it in writing and done. The other question really is, when do there's an affirmative obligation to report different violations to the government. And, it's nuanced on what needs to get reported and what does not need to get reported. The issue I talked about with the guy falsifying timesheets. Well, thankfully, that was a firm fixed price contract, so the government wasn't paying us any more money because of the fraudulent submitted timesheets. So if we had billed the government for that time that wasn't performed, we would have needed to tell the government and give the money back. And if we didn't, we would have been, violating laws. But once you put it all together and you finalize and say, okay, here's what's violated. It was only company policies. You only ripped off the company, not the government. So, we're going to fire you and send you away, but we didn't have to report it. So you really need to, at the end of these things, put some real thought behind what needs to get reported and what does not. Because I will tell you, I'm all about disclosure, but I'm all about not disclosing what you don't need to. Because if the government hears, hey, we had this minor issue, we took care of it, the government's going to want to get a lot more information and want to dig into it way more than you need to. So you want to disclose when you have to. You don't want to disclose when you don't have to. And there's a very fine line that you need to walk at the wrap up of this investigation. You're muted, Merritt.
Lewis is so loud. He's in the office next door to me. I'm trying to make sure people aren't hearing him twice. Alan, what about withdrawal? If you provide a notice to the carrier or your broker, you need to sort of withdraw that? Or I guess lots of times if you find there's nothing to the allegation and you try to resolve it internally, you may not have ever made a report.
Right. So if you haven't made a report, there's obviously nothing to withdraw, but it's a great point is that, and final thought on this is, carriers and adjusters are in the business of adjusting claims, right? So they're waiting on updates from anywhere from 100 different assigned claims that they've got. I've seen loss runs where claims have been left open for years, which means they'll sit on those loss runs for 5 years post-closure. So my only advice in that regards is, if you did get into an instance or a claim where the severity of it or the nuances of it required us to open a claim, the adjuster is going to wait for the information. They're going to collect the information, but then they're kind of going to leave it in our court to settle it, or have it the dispute remedied. If we don't notify them that this has been withdrawn or it has been resolved, they'll leave it open. So it's sort of leaves a bad taste in my mouth too, personally. But don't expect the adjuster to touch base once a month and say, hey, how's that claim going? Right? Or, hey, what's the latest on that discrimination allegation? Right? It doesn't work that way. They benefit from having open claims because it makes you less marketable. So
right.
It's very important that we check the loss runs, I'd say at least once a year, to make sure there's no tails left out.
And so you have to know that if you filed a claim or notified your broker, make sure once it's resolved, you try to close the loop there.
Definitely.
So I've tried to address some of the questions that we've had during the presentation. Why don't we sort of have final thoughts? And Alan, I'd sort of like you to answer, what are some of the biggest gaps that you've seen with some of the clients that sort of come to you as new clients, or stories that you've heard where they haven't had coverage and they really should have had it in place? What's sort of that number one recommendation you have for a new client?
That's
as it relates to compliance and, on topic.
So as it relates to compliance, when it comes to the size of the potential exposure versus the cost to appropriately insure it, it's going to be one of two things. It's either going to be having appropriate ERISA coverage, right? And that's Employee Retirement Income Securities Act.
So anyone that has a 401k or anything along those lines, you need to have
right. It's $200 a year to have like $1 million for an ERISA bond if you make a mistake, right, in the administration of your employee's 401k. And I know that's not necessarily, it is compliance, but
yep.
I've seen, $100,000 mistakes because you put it in this fund versus that fund, or the employee requested that you increase it from, the 4% withholding to, the maximum 18%. Well, that could go unnoticed by the employee and the HR or financial, 401k manager for years. And then it's like, well, I just missed out on that 12% difference in returns. That cost my 401k X amount of dollars. Then another thing would be having the defense costs outside the limits. You don't want to have $1 million claim, incur, $300,000 worth of, defense costs and legal fees, and then realize that that's eating away at your actual limits of liability.
Great.
Good time at the dog. So,
very good. Well, with that barking, Lewis, final thoughts for you that you see, or the number one recommendation you provide clients in this regard, besides document, and be prepared?
Yeah, well, I'm going to go back to the policies. You need a good policy. You need a good, well thought out policy. If you don't have one, you need to put one in place. And you'd rather pay me for a few hours of work to put a good policy in place for you than have to scramble after the fact and spend a lot more money because you don't have good policies.
Yeah, and I'll reiterate that after practicing for 20 plus years and running this firm for 16 years now, the clients that are oftentimes most successful and do well, they have the policies, procedures, they do the upfront work, and we'll sometimes say the way to hurt a relationship with a great legal client of our firm is them getting involved in expensive litigation, because no one wants to pay an attorney for litigation. And as Lewis said, you'd rather pay up front, get the policies and procedures in place, be smart about an investigation, and avoid those litigation costs, downstream. So with that, I think, Lewis, thank you. Thank you to Alan and everyone at Sahouri for helping organize this.
Thanks for moderating.
I know that parts 1, 2, and 3 will be on websites at General Counsel and at Sahouri, so you can go there, and please follow up with myself, Lewis, or Alan if you have any questions. So with that, thank you so much, and I guess, Sydney, you can end the presentation.
All right. Thank you, everyone.
Bye-bye.
Bye.